Well, I would like to thank Crossroads for giving me the honor of sharing this podium with Professor Robert George, that was, as you just heard, one of the most brilliant and profound natural law scholar of our times. But as he told, he's also my great friend. So somehow Crossroads gave me the opportunity of not only listening to, but also experimenting what Professor George was saying, that friendship is one of our basic human good and is something really necessary to human flourishing. So I must thank friends here for this invitation. Obviously, after such a brilliant lecture, I have also to do another thing. I must apologize for my English, and obviously, please try to be merciful, patient for this. At least think that I am really courageous trying to address these arguments after the lecture of Professor George. So please, I trust in your patience. So the title of my talk would be, trying to answer to the question of our title, it would be the original source of law, our human experience. One of the greatest American Protestant theologian, Reinhold Niebuhr, summarized in a wonderful expression the deadly obstacle to a true knowledge. He said, "Nothing is so incredible as the answer to an unasked question." As if to say, it's really impossible to discover what you think you have already discovered. In other words, what makes totally meaningless the adventure of knowledge and shuts any kind of reasonable openness of our mind to external reality is prejudice. The certainty of having already reached a sufficient knowledge of something that any further effort or change is practically impossible. Very often, we assimilate these prejudices through a process of social or cultural osmosis. They aren't even consciously admitted, but are sort of built-in interpretive schemes we find within ourselves without any clear idea of how they were produced or by whom. On the contrary, as Niebuhr stated, only a really open question can energize our reason to engage that endless work that is our knowledge. Our journey always approximated towards the truth, or at least towards a more comprehensive account of what is in front of our eyes. I think that the issues we are discussing this evening, true sources of law, the justice of legal systems, are issues full of prejudices. Law, legislation, politics are facts before than ideas, very concrete and tangible things, capable of deeply affecting our behavior. Let's think about discussion here in the United States about the new presidential campaign, or think about this economic financial crisis. For this very simple reason, we all tend to have implicitly or explicitly a distinct idea of these facts. My point is that many times this idea could be more a prejudice than a rational reflection upon our own experience of it. I would like to give you two examples of these prejudices. The first one can be summarized in this way. The natural law theory, being a typical product of Catholic doctrine, is practically useless for solving today's legal problems. It could appear to be a paradox, but in the present day Europe, I'm speaking mainly about my experience of teaching and living in Europe, but I think that something is happening also here in this field. But it could be a paradox, but in present day Europe, the debate on natural law is a sort of taboo. It's a prohibited argument, and it's a paradox insofar as we've heard that the natural law theory was mainly produced by European thinkers, from Aristotle to Aquinas, from Cicero, Grotius, Locke, Hobbes, Hume. Even Cardinal Joseph Ratzinger, in a famous dialogue with Jürgen Habermas, declared that, unfortunately, the natural law instrument has become blunt. And it's interesting to notice that President Pope Benedict is definitely more optimistic on the role of natural law than Cardinal Ratzinger. But the reasons for this deeply hostile attitude could be summarized in the following way. Natural law is supposed to be a law, that is a regulation of human affairs, that we may derive directly from nature. Using the words of the most famous anti-natural law theorist in Europe, Hans Kelsen, he said, we can deduce from nature just rules of human behavior only because and so far as nature is conceived of as a revelation of God's will, so that examining nature amounts to exploring God's will. As a matter of fact, there is no natural law doctrine of any importance which has not a more or less religious character. End of quotation. So natural law theory is simply a way through which confessional groups, in Europe mainly Christians, try to impose their own religious views on the others. Well, given these, let's say, osmotic prejudice, in 2007 I had the idea of inviting one of the most famous experts in natural law theory to Italy to teach a course exactly trying to understand these if these judgments were mere prejudices or true flaws in the doctrine. That professor was Robert George. And in a lecture entitled Kelsen and Natural Law, he plainly demonstrated the surprising conclusion for all the Italians gathered there. Simply that all of Kelsen's very famous objections to natural law were directed toward a non-existing target. That is, the natural law theory he was fiercely fighting against had nothing to do with the most famous and influential of all natural law doctrines, namely the one provided by St. Thomas Aquinas, and let's say that today has among the most important voices Professor George, Professor Finis, and the others we have just heard. So the arrows launched and the bullets fired by European legal culture during the last decades have been targeted against only a parody of natural law tradition. You may imagine our surprise when Professor George asked, does, as we heard just a few minutes ago, does Aquinas' natural law theory presuppose religious premises? Can it be accepted only by those who presuppose God's existence and believe that he has revealed something of his will for human beings? The answer of these questions to these questions must be no. By the way, in 2011, we translated those lectures into Italian. We published a book. The title is Il diritto naturale nell'età del pluralismo. The second great prejudice I would like to highlight is what I named the statist prejudice. If you ask a law school student in Italy, but again, the phenomenon is growing also here. I recently taught in an American university, and I had the same feeling. What is the law? What is a legal system? A vast majority of them will answer that the law is a social regulation made by whoever has public authority. Law implies the state. This was the sharp and clear-cut opening sentence of a 1920s law textbook in Italy. As you can imagine, the sentence was not surprising at all during the fascist Italy of 1920s. It is much more shocking to feel that nothing has substantially changed in public opinion since then. After tragedies such as the European totalitarian regimes before World War II, in which Hannah Arendt pointed out through the state, through formal laws and offices, through legal procedures and majority decisions, it was established that some human beings were not anymore men, and so they could be eliminated. Why do I consider also this statist prejudice, despite being so diffused, unfounded? You may give many accounts for that, but I think that most persuasive is that this assumption is completely against history. I always say to my students, let's imagine that all the history of legal civilization is put on a line 1 meter long, starting from, let's say, pre-Egyptian Akkadic legal system, 2000 BC, all the way through Greek, Roman, medieval, until today, 2000 AD. Well, in this 1 meter long, the state, as we know it today, the institution having the legitimate monopoly of the rulemaking, would occupy at the maximum only the last 5 centimeters of that line, 2 centuries, 19th and 20th. Thus, during more than 3,000 years, we have had law, legal systems, but we didn't have the state. And if we try to imagine our future, I'm not so convinced that the state, in this old way, the modern state that was born from the liberal revolutions in Europe at least, that this kind of state will easily keep its exclusive lawmaking power also in this new 21st century. Therefore, to avoid these preconceptional prejudices, from which starting point should we then begin? We have, I think, only 2 possible alternatives, either to start from prejudices, or in a most noble and organized way from ideologies, or to start from our own experience. I and some other colleagues involved in legal studies, Professor Carrozza in Notre Dame, Professoressa Cartabia, now appointed Constitutional Justice in Italy, Professoressa Violini, we are tempted to follow the second path to address the question of our seminar today. So let's begin from our human elementary experience. It is decisive to notice that this is not a concept we conceived theoretically, but it emerged in the thought and writings of Father Luigi Giussani, an Italian priest, founder of the movement of communion and liberation, who challenged us to use this experience through the education we received. What is this elementary experience? I will limit myself only to a description that appears on one book, The Religious Sense, and sorry for the long quotation. What constitutes this original elementary experience? It can be described as a complex of needs and evidences which accompany us as we come face to face with all that exists. These needs can be given many names, can be summarized with different expressions. For example, need for happiness, need for truth, need for justice. An Eskimo mother, a mother from Tierra del Fuego, and the Japanese mother all give birth to human beings recognizable as such, both by their exterior aspects and their interior stamp. Thus, when they will say I, they will use this expression to refer to a multiplicity of elements derived from diverse histories, traditions, circumstances, but undoubtedly, when they say I, they will also use this term to indicate an inner countenance, a heart, the Bible would say, which is the same in each of them, even if translated in most diverse ways. End of quotations. So, elementary experience is defined as a complex of needs and evidences, which in the biblical narrative was denoted by the word heart. It is an original, inherent criterion which humans have called by many names: pursuit of happiness, you would say, truth, goodness, justice. These findings and needs characterize what is human in each of us. It is evident that an Eskimo and a European, an African, an Asian are very different one from the other. But it's also evident that they are all identifiable as human persons. What do they have in common? And in what do they differ from other levels of human beings? Biology or chemistry would be of very little help in answering that question. Instead, it's clear that it's the same humanity, so this elementary experience, that is expressed in different forms and that allows a special relation between them. This even superficial reconstruction suffices at least to clarify what, in my opinion, elementary experience is not. The concept of elementary experience is not a new or old set of moral principles intended to guide human conduct. It's rather presented as a species of the genus experience. It therefore concerns the relationship between the self and reality. And for this reason, it is clear that the concept of elementary experience must equally not be confused with a new theory of law, or especially a new theory of natural law, that, by the way, as we've heard, doesn't need to be replaced or supported. As Father Julian Carron explained in its preface to our book, it would be a mistake to reduce elementary experience to a doctrine or to other abstract formulas to be imposed mechanically upon reality. On the contrary, it's interesting to verify the ability of an elementary experience to illuminate the unanswered questions driving the current debate surrounding law and the definition of new rights. So let's try to give a concrete answer to the questions we are discussing today, trying to use our elementary experience. The first point is, why do we obey law? The title of our conference, The Original Source of Law, could be rephrased in this way. Why do people obey the rules of law? Why do we obey at all? Once, when I was a young student at the university, I tried to put this question to my professor, a very famous professor. And he looked at me very strangely, said, what? We are lawyers. We are not interested when people obey, but we are interested when people don't obey. So we are paid for this. So please, leave those strange ideas. And all the theories that dominate the contemporary scene on that point are of essentially utilitarian or socioeconomic background. The general belief is that the mechanism by which law affects human behavior is the threat of punishment. If you kill someone, I will kill you too, you would say in your pragmatic and a little bit rude country. In Europe, we should say, I'll put you in prison. But in both cases, the mechanism is the same, that Pavlovian conditioned reaction we used to train animals. Pleasure permitted, pain prohibited. Another widely diffused commonplace is that people usually obey laws under the force of social convention or habits. Yet these theories are completely silent in front of any kind of tyranny and any inhuman rule against which throughout the history people have often rebelled, even at risk of being subjected to this very punishment or to run against the social mainstream. I'm fully aware that the role played by punishment or by social habits in defining a legal system is very important, but can these external reasons alone determine our observance of law? The reality is that the reason why people obey the law cannot itself be legal. The proposition, you must obey the law, what always Kelsen, the famous anti-natural law thinker, what Kelsen defined the Grundnorm, you must obey the law, is not a legal norm. Despite the attempts of contemporary legal theory, law cannot reasonably be self-founding. This claim of contemporary legal theorists reminds me of the famous Baron von Munchausen, who wanted to get out of a puddle by pulling himself up by his own hair, you know. Not hair, sorry. People obey the law because, at base and in its entirety, they believe it corresponds to a need for justice. That is to say, there are adequate reasons to organize people in a cooperative, as we had, and non-hostile way. This does not mean that we cannot think deeply and seriously that a single given rule or regulation is unjust. It is the existence of the legal system in its entirety that is thought to be an indispensable condition for one's own good and a necessity proportionate to the dignity and the utility of human beings. If it were not this way, if this link to our need of justice, to our elementary experience did not exist, we couldn't explain why laws are so different in societies and cultures. Those changes are testimony of the humanity's attempts, ever imperfect and evolving, to align the rules of living together in society with a certain ideal image that stimulates us from within. This is Jusan. However, this connection to human experience shows us also the other side of the coin, precisely because this demand for justice exists at the base of human obedience, and precisely because it is characterized not only by needs, but also by evidences. It constitutes at the same time a point of reference for that system. Therefore, it allows us over time to adjust the existent with the ideal, correcting those laws considered inadequate or unjust. In this perspective, we could understand better the astonishing question and answer of Pope Benedict XVI in his speech at Bundestag in Berlin. How do we recognize what is right? In history, this is the answer of the Pope, in history, systems of law have almost always been based on religion, Decisions regarding what was to be lawful among men were taken with reference to the divinity. Unlike other great religions, Christianity has never proposed a revealed law to the state and to society. That is to say, a juridical order derived from revelation. Instead, it has pointed to nature and reason as true sources of law, and to harmony of objective and subjective reason, which naturally presupposes that both spheres are rooted in the creative reason of God. The problem, then, is not how to translate religious or moral teachings into law, but how do we use our reason to understand nature? Which idea of nature and reason do we have today? How, using reason and observing nature, we can identify these fundamental principles of justice? The elementary experience coincides precisely with this open and not reduced use of reason in front of the nature, recalled by Pope Benedict. As we said in the beginning, it's a certain way of experiencing reality that doesn't block its trajectory only at the measure, but goes deeper to the origin of needs and questions reality itself arises. There is another point that I'd like to touch, that is, everyone lives immersed in a particular economy, culture, religion, and therefore in a particular legal political system as well. What happens when these different worlds come into contact? This question today has become highly controversial because of the globalization of the economy and the worldwide migrations connected to the collapse of autocratic regimes. A good departure point on this question requires us to distinguish between multiculturalism as a fact and multiculturalism as a philosophical political orientation. When the multicultural context, that is, people of different culture or religion sharing the same territory, has existed forever, multiculturalism, or better probably multicultural relativism, it's only one of these cultures. This multiculturalism is based on an anthropological premise that asserts the absolute otherness and incomparability of cultures, which makes each one unique and different from all the others, totally incapable of dialogue, but only of cross monologues. Multiculturalism, therefore, is grounded on the impossibility of the category of the encounter, and precisely because it denies that fundamental structure that allows human beings, no matter how different they are, to recognize themselves nonetheless as human beings. So, using my terms, this multicultural ideology is based on the practical negation of what we call here elementary experience. Now, the interesting point is that multiculturalism proposes the separation between different culture as an axiom, as an assumption not demonstrated or proved, but simply presupposed to justify what we can observe. Having our culture nothing in common, it is completely impossible to think of a policy of integration understood as the recognition of some common values that must be obeyed. Multicultural policies end up, and we can see, this is growing, multicultural policies end up becoming mere policies of subdivision, of parceling out spaces in material sense, in which in each group lives shut up in its diversity. What could we say in front of this absolute lack of cultural and legal dialogue that could seem to be based on the absence of any possible elementary experience among human beings? Well, the most impressive demonstration of the falseness of this assumption, according to which different cultures cannot meet and cannot learn one from the other, is that in history these encounters have in fact occurred. In fact, our entire civil and political history is the history of these encounters. With the category of the encounter, without the category of encounter, there is no real possibility of a sound use of reason, and therefore of knowledge. If we think of the most recent historical period following the World War II, law, especially constitutional law and international law, is a great testimony of how encounters between different political cultures, religions, and different ethnic groups were possible. think only to the approval of the Universal Declaration of Human Rights in 1948. The wonderful book of Marianne Glendon, A World Made New, is an amazing documentation that, against all odds, the encounter among differences is possible because it happened. And we could cite other emblematic examples during the same years as the Italian Constitution, the German, the Spanish. So, must we confine to the history or to post-war constitutions the birth of real dialogue? Can we really say that they are only old memories of the past? I think that if we look around us with an open gaze, using our elementary experience, we would realize that examples of these encounters are much more frequent of what one could expect. I'm still moved thinking about a lecture I've heard here, organized by Crossroads, made by Professor Wael Farouk here of NYU, Islamic professor that is teaching here. And all these cases are decisive to recognize that our human experience implies the value of pluralism, that is the opposite of that of multiculturalism in the definition that I used here. The cultural assumption of pluralism is that a common ground exists and is prior to law, while that of multiculturalism denies this possibility, asserting that the common good can be produced only through law, legal procedures and institutions. In the relativistic multicultural approach, there is no humanity and unity prior to law. On the contrary, all the pluralistic post-World War II constitution, just as your American constitution, were born precisely to assert the opposite. There is something prior to law. There is something that law has to respect. I want to conclude by drawing your attention on a last point. The legal panorama today is ever more densely populated by absolute rights. That is, by legal claims of non-interference from anybody with our choices. These kinds of rights were born mainly to defend the dignity of individuals against power, be it the state or private powers. But today we are facing a sort of radical transformation of these rights. Law is used to obtain artificially what nature doesn't allow, that the person can cut herself off completely from the others. There is a wonderful passage in Chesterton that is really enlightening. The ultimate authority is will, not reason. The supreme point is not why a man demands a thing, but the fact that he does demand it. They say that choice is itself the divine thing. A man does not act for his happiness, but from his will. He doesn't say, jam will make me happy, but simply, I want jam. In such a landscape, populated by insatiable rights and absolute differences, all the relations turn out to be conflicts, and the most pressing social need becomes that of regulation and security. Everyone is desperately looking for an entity to manage the social conflict, or to give up their persons, what he hopes. As Father Caron recently said, this is the paradox of modernity. The more it encourages individualism, the more it is forced to multiply the rules to restrain the wolf lurking in each of us. The evident failure of this approach is before the eyes of all today. There will be never enough rules to tame wolves. And this modernity is founded on what Giussani called positivism. That positivism that dominates modern man and excludes the call emanating from our original relationship with things. It would have us accept appearances, and this is suffocating. And as the Pope in a recent speak used the same word, the human person who seeks to exist solely positivistically within the calculable and measurable ends up suffocated. So in this dark Blade Runner atmosphere, more and more populated by human beings, by their replicants, there is still a firm point of departure, that beating heart that makes us human, this elementary experience which each of us can loyally trace in ourselves, that allows us to perceive the other as a good, so much so that solidarity goes into action, to the point of generating a people. This is my very last conclusion. A just legal system is not a scheme or an abstract model applied to reality. It is an ever-approximate attempt to facilitate social conditions compatible and favorable with the human flourishing. This presupposes a sound and not reduced interaction between man and reality, social and natural reality. That is what we call, what I try to call here, our elementary experience in action. Therefore, the fundamental test, the most reliable indicator of the justice of a legal system, is if it allows, in fact, the existence of a vital and lively society, of a free and generative people.